All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Good morning. Please be seated. We are here in our cause number CACV120681 involving KB Home Tucson Inc. versus the Charter Oak Fire Insurance Company and others. It's the time set for oral argument. Each side will have 20 minutes to present. The appellant, if you'd like to save time for a rebuttal, we will let you manage your time. We are recording the arguments so that if we have to review them, we will have a good memory of what you may have told us. So as you come forward, please identify yourself and your client. We're also told we may also be videotaping these, putting them on YouTube and putting them to music, I understand, but well, maybe not. But something you can do later in life. We were told this a couple of weeks ago and it didn't work, so who knows if it's up and at 'em at this point in time, but we just wanted to let people know. We've read the briefs in this matter, to include the briefs filed by the amicus. We have conferenced this case. We think we have an understanding of what it's about. With that in mind, counsel?
Thank you. Good morning, and I would like to reserve 5 minutes for a rebuttal. May it please the court, my name is Peter Molinar. I am joined today by my partner, John Flynn. We represent KB Home Tucson, Inc. This matter involves two primary issues. The first is whether KB Home's contract with its subcontractor, GRG Construction, its subsequent insurance requirements and related correspondence, and certificates of insurance received from GRG's insurance agent, Drockman Lead, constitute a written agreement that GRG was to name KB Home as an additional insured under GRG's policies with Charter Oak Travelers.
Did the certificates of insurance regarding Charter Oak or Travelers indicate that KB was an additional insured?
Yes, Your Honor. The insurance certificates for the Travelers Charter Oak years stated on them KB Home is an additional insured. Any and all jobs, that was for the first year, and for the second year it stated KB Home is an additional insured, general liability coverage as respect to work performed by the named insured.
And KB Homes was down at the lower left of the standard accord form listed as the certificate holder.
Correct. Correct. The second issue is whether Drockman Lead and American E&S made actionable misrepresentations in certificates of insurance and an endorsement stating that KB Home was an additional insured under GRG's policies with Evanston Insurance Company. I'll take these two issues in turn. For the Charter Oak policy, for both policies, they contain a blanket insured endorsement. The language of the blanket insured endorsement provided in material respects that who was an insured would include any organization GRG was required to include as an additional insured on the policy by written contract or written agreement in effect during this policy period and executed prior to the occurrence of any loss.
Do you view there to be a difference between a written contract or a written agreement?
Yes, Your Honor. And in fact, Charter Oak testified during its Rule 30b-6 deposition that Charter Oak believes that there is a difference between agreement and contract, although Charter Oak's designee was unable to identify what that distinction is. Use of the word "or" in between written contract and written agreement also indicates that there is a difference between the two definitions. As set forth in our brief...
What is that difference? Is that what you're going to? Sorry.
Yes, Your Honor. An agreement, as set forth in our brief, an agreement is a manifestation of mutual assent. So it's an agreement between two parties that may lack one or more of the essential elements for a legally binding contract. Here, there was evidence in front of the trial court of an agreement. In fact, the trial court expressly found that based on GRG's action, it found every indication that the parties had agreed that KB Home would be an additional insured. Looking at some of the evidence of an agreement, we have, starting first with the KB Home contract, there's a Section 7, there's actually two Section 7s. The first states that GRG will comply with all rules, regulations, and requirements of KB Home. The Section...
Well, and that's the part of the contract that leads to, at least under your analysis, to other agreements, correct?
Correct.
Because you say if you've got to have, you've got to name us as an additional insurer. I think the record suggests that KB Homes did that as opposed to entering into its usual contract with its sub so it can continue and finish the job. I understand.
There's a distinction between the two contracts that KB Home was using at that time period. There was the land contract, which was the shorter form contract, which is at issue in this case. Then there was a more comprehensive contract for vertical trades. However, the testimony that was given by KB Home's 30B6 designee was that KB Home did not use the vertical trade contracts for its land contracts and vice versa. The land contract department, the land department, wanted a shorter form so that it believed that it could move a little bit quicker. This was back when the economy was much stronger than it has been recently. But GRG testified, Tom Greer, who's the vice president at GRG, testified that it understood that one of the requirements that it had to comply with, and it also identified that there were other requirements outside the contract, but one of the requirements it had to comply with was KB Home's insurance requirements. Those were provided each year, usually about the time that the prior insurance coverage was to lapse. In response to receiving the insurance requirements, GRG forwarded them to its agent, Drockman Lead, and requested that Drockman Lead procure the coverage. Drockman Lead, as GRG's agent, then issued certificates of insurance to KB Home stating that KB Home was an additional insured. This is all evidence of an agreement. Furthermore, GRG testified, or Tom Greer testified, that it completely understood that it was complying with this agreement. So it was honoring it and complying it by forwarding these insurance requirements to Drockman Lead. And that had KB Home objected, it would have gone back to Drockman Lead and requested that KB Home be given the insurance that it had requested.
I think the other side, I assume the other side is arguing that there needs to be, if not in the fundamental subcontractor itself, there needs to be at least a separate contract or agreement in writing signed by both parties. Why isn't that? I mean, that when we talk about contracts, agreements, and execution, as the trial court noted, we're normally talking about something that's signed by both parties. Why is that, in your view, not required here?
Yes, Your Honor, and we do concede that there needs to be a written agreement. But as far as executed, the term executed is actually not defined in the Charter Oak policy. And it does not state...
Use a normal definition then, right?
Correct. And as we cite in our brief, executed means completed, carried into full effect, already done, or performed.
It could also mean signed, right?
That is one definition. What is absent, though, from the endorsement is any requirement that it be signed by GRG. It doesn't say signed by you, which would be a defined term under the policy, or signed by the name insured.
We don't normally have, correct me if I'm wrong, I started to say we don't normally have written contracts or written agreements, if that means something more broad, perhaps. We don't normally have written agreements signed by only one side, or not signed at all. Normally, they're signed by both sides.
But we are bound by the language of the endorsement, and it merely says executed prior to the occurrence of any such loss. So here we have, first of all, again, we have the contract that says, that references requirements. We have insurance requirements being forwarded once a year with a letter stating, as per your agreement with KB Home, you agree to procure this coverage. Then we have GRG forwarding that to Drockman Lead, and Drockman Lead issuing certificates stating KB Home was an additional insured.
And if I followed you correctly, you also have GRG testifying that we intended and we understood and we undertook to make them an additional insured.
Correct. Correct.
But here it's a requirement. What GRG says wouldn't necessarily be very relevant, would it? If the point is to put the insurance company on notice that there's some sort of written agreement, shouldn't we be able to look to the documents to make that determination without relying on testimony from someone from GRG?
Well, we do have, again, the contract, the insurance requirements, the accompanying correspondence, and the certificates. GRG's testimony is important because here the only party that is contesting whether or not there was a written agreement is third-party Charter Oak Travelers, the two actual parties to the subcontract and that were performing under that subcontract do not contest that there was a written agreement.
Let me ask, though, let's say we were just talking about a contract and there's a requirement that you have a written contract, and you have a contract that's only signed by one party. In your view, can we find the existence of a written contract by virtue of conduct of the parties without both parties signing the contract?
Yes, Your Honor. I think you can find the existence of a written agreement by looking at the documents that existed at that time, as well as the conduct of the parties.
So we just have one contract, just one document, only one side signs it. But then the other side begins to perform. You're saying that would establish a written contract?
I'm saying that would establish a written agreement. There's a distinction between written contract and written agreement, and to construe the two phrases as requiring all the legal elements of a contract would be to read out the word agreement.
How about if there's nothing in writing? Here I understand you can, I presume you're relying on the documents that GRG orders. Those are documents that are in writing. But my question, I guess, is if there's nothing like that and all we have is someone saying that they've agreed, would that be a different case, or is that are you suggesting that you can still have a written contract if it's only signed by one party? There's only a writing from one party, no writing from the other side.
If there's only a writing from one party, well, the definition of agreement requires mutual assent. So we have to have evidence of the assent of GRG. So here we have documents that, coming from Drockman Lead, its agent, evidencing that assent. So we have to have a written agreement. It does have to be contained in written documents, but there's no requirement that those documents have to be signed by both parties. Moving on to the issue of Drockman Lead. For a period of 4 years, Drockman Lead received a request from GRG Construction to add KB Home as an additional insured. For 4 years, it issued certificates to KB Home stating it was an additional insured. For the last year, KB Home's insurance requirements changed, and they stated that KB Home wanted to be named as an additional insured on an endorsement in the policy. In response to that request, Drockman Lead issued a certificate stating that KB Home was additional insured as per an attached endorsement. That endorsement, which we refer to as a KB Home endorsement, expressly had KB Home's name on it and its address. KB Home relied upon that certificate and that endorsement, and
Was the endorsement part of the policy?
the endorsement was not part of the policy. According to Evanston, the endorsement was not contained in its underwriting file, and Drockman Lead never obtained permission from Evanston to issue that endorsement. In fact, the form of the endorsement at the bottom left is not even an authorized form under the Evanston renewal policy. Therefore, there's no way that that endorsement in itself could have conferred any coverage to KB Home. Drockman Lead also knew that it had no authority to issue that endorsement. According to Evanston, back in July 2001, Evanston made it clear to Drockman Lee that it could not issue an additional insured endorsement without Evanston's permission. But that is exactly what they did in this case. They issued a certificate saying KB Home is additional insured per this endorsement. That representation, that certificate, and that endorsement were false, and KB Home relied on it to its detriment.
Could we go back a second to the fundamental question of the import of these certificates of insurance? As I recall, they also have a disclaimer in them saying that this doesn't affect or change the coverage. That's a poor paraphrase, but I suspect you know what I'm referring to.
Correct. The certificates.
How can that do anything?
Correct. The certificates contain the standard limiting language that says that it cannot alter or amend the policy. KB Home relied on the certificates as evidence of the policies, evidence that it was an additional insured. Furthermore, that language is part of the form. Meanwhile, the description that I described was actually typed in by Drockman Lee.
It doesn't. Does the standard language say it cannot change the coverage, or does it say it cannot change the policy?
I believe it says it cannot alter or amend the terms of the policy.
So KB gets a copy of the policy, the Evanston policy or the charter policy, along with the certificate saying they're an added insured. Doesn't KB have a responsibility to look at the actual insurance policy to make sure it's not, for example, a limit on coverage of $5,000? I mean, isn't there an obligation on KB to figure out if what's in the insurance carrier's policy, if what's in there adequately covers what they're hoping to have covered? Why isn't that their responsibility as opposed to Drockman's, I guess is my question.
KB Home did not receive a copy of the Evanston policies, and in fact, we quoted from additional insured treatise that states that in the construction industry, the certificate is deemed the method for conveying whether or not this additional insured coverage has been obtained. Another important point to remember is that
But
KB
how
asked...
do they know what the coverage is? Isn't there some obligation to ascertain whether they've satisfied the requirements of that contract?
Well, the certificate in itself will list some of the limits. It doesn't have the declaration page, but it will list some of the limits. And then KB Home did receive that endorsement, and the endorsement excuse me, does actually modify the policy. So in this case, KB Home requested the endorsement to modify the policy, received a certificate stating it was additional insured, and an endorsement with KB Home's name on it. I see that I'm at 4 minutes. Unless Corey has any other question, I'd like to reserve some time.
Thank you.
Thank you.
Good morning. May it please the court, my name is William Reeves. I represent Charter Oak and the Travelers Property entity. I'd like to take 10 minutes. I'm going to give 10 minutes to co-counsel per agreement, so hopefully I honor that. Threshold issue, Your Honors. Two entities named in this case, Charter Oak, Travelers Property. Travelers Property didn't issue the policies, didn't participate whatsoever in any aspect of the claim. There's no evidence as to agency. There's no evidence that it should be in this case. And so as to Travelers Property, I respectfully submit that the judgment should be upheld regardless of what we do today.
If we reversed as to Charter Oak, you're asking us to make a distinction?
I am, Your Honor, in fact.
Is the record clear on that?
It is, Your Honor. In terms of this insured issue, we have a couple things that are undisputed, which get us to where we are. It's undisputed that KB's not a named insured under the Charter Oak policies. And bear in mind, counsel refers to the Charter Oak policies. Charter Oak issued those policies. KB's not a named insured under those. It's also undisputed that the subcontract agreement in and of itself doesn't include an additional insured requirement. That's not disputed. That's in the record before this court. And so what we're doing here is we're working within an endorsement that extends additional insured coverage, but does so under certain requirements. And so that's the issue at hand relative to the fact that we have a subcontract that is deficient, that doesn't include additional insured requirement, yet can we still kind of get in the back door what we couldn't get into the front door?
Is there something in your policy that requires that the written agreement or contract for additional insured coverage must be in the basic construction subcontract?
No, it must be part of a written agreement or a written contract that's executed, so
It can be separate.
Oh, it certainly can, but you must have consideration relative to that separate agreement. And that's something that is very significant relative to all of this. We have flyers that were sent, and part of frustration relative to Charter Oak's vantage point is the record. What's before the record? What is the record relative to GRG? What does that record reflect relative to a quote-unquote meeting of the minds? What does that record reflect relative to an agreement? We took pains relative to our brief to go through the record, cite to the record, properly cite to the record, and direct this court to the evidence that is the record. The record doesn't show an agreement. The record doesn't show a meeting of the minds. The record shows flyers that were sent subsequent. And subsequent is a very important word relative to this, because if it was contemporaneous, if this thing was attached to the agreement, attached to the contract that the party signed, well, we wouldn't be here. Because
Does the contract require that they be contemporaneous? Why couldn't you have a subsequently entered into agreement?
you can, Your Honor, but you must have consideration relative to that. You can't just go after the contract and say, you know what, I'm going to change the terms of the contract. I'm going to add a term.
Isn't the suggestion, though, that this is just part of the considerations to keep working on this project? If that's part of, aren't they relying on provision 7 of the contract that says there are requirements, and everyone seems to agree that this is a requirement to have the ongoing insurance?
When you say everyone agrees, certainly you didn't hear that from GRG. They never rendered an agreement relative to this. They wanted to accommodate relative to a party they wanted to get paid, but they never agreed to it.
Why isn't that an agreement? If someone sends a letter saying this is what we expect you to do, and then someone responds by doing that, and there's some evidence of that in a writing, why doesn't that constitute a written agreement?
They didn't do anything. That's the part that I guess I'm lost at. When you say they sent something and asked for something, they asked for a certificate, and then they bury in there a requirement. There's no mindset relative to GRG of reading that provision and saying, I agree to that, go and comply with that. That's not before this court.
Wasn't it GRG that directs Drockman Lead to send the certificate saying that KB is a named insured?
They say comply if you can. They say send a certificate. They don't go through and say comply with each of these requirements. They frankly send it to the broker. The broker sends off the certificate, and GRG testified. They said if there was an issue, then they would deal with it as it came up. But they did not render any, there was no evidence they even read the requirements. I mean, that's what, when we talk about a mutual assent.
You're saying they didn't read the letter saying we want to be listed as a named insured on the policy?
That's correct. There's no evidence before this court that they read that letter.
Other than them directing Drockman Lead to do something?
Isn't
that at least a factual issue?
When you use the word directed, they simply forwarded it along. So, no, it isn't a factual issue from my estimation, because again, we have two core requirements. We have an executor requirement and we have a consideration requirement. And so to your point relative to rules and regulations.
And excuse me for interrupting, but what's the consideration requirement? Can't you have a written agreement to do something? Why does that necessarily, does there have to be a specific consideration beyond perhaps just continuing to work on the?
It certainly does. And I may mispronounce it, but the Damas case that I cited in our brief is directly on point relative to that. It's an employment manual case, and that precise argument was made that, look, the consideration, we subsequently changed the employment contract, and so we're going to throw in terms and conditions. And the employer there said, well, the consideration is I let you continue to work here. And the court said, no. You already had that. That was already part of the original agreement. If you want to change it, you need to give new consideration. And so that's the issue here relative to new consideration. The concept of letting someone stay on the job, that's already provided for relative to the agreement that exists in place. It must be new consideration.
Because the agreement really was between the predecessor to KB
Yes.
and KB, and so they really didn't, your argument is they didn't really ask for anything more, or they didn't give any more consideration for what they wanted.
They certainly did, and again, it goes to my point. If these, when he uses the word subsequent insurance requirements, if these were contemporaneous insurance requirements that were incorporated into the agreement that was signed in May of 1999, it'd be a different analysis. That would be a attachment, a written attachment to a written agreement that's executed by the parties, signed by the parties, and there would be consideration. But in a circumstance where you send it after the fact, and you bury it within there. I mean, do look at the record relative to this. It's not patently clear what they're seeking.
When we're talking about after the fact, where the coverage issue doesn't come up until after that, it's certainly prior to a request for coverage, and your client doesn't require, do they, that the subcontractor, that GRG notify them that they're adding someone ahead of time, do they?
No, but they require clarity relative to a written contract or a written agreement that's
It's an after-the-fact analysis, though, right? Whether they've done that. So,
by design, it's after the fact, yes, Your Honor. But
so hasn't there already been essentially, and I don't mean to confuse terms, but consideration? The insurance company is expecting that other groups, someone else may be added as a named insured to the policy. That's already part of the negotiations with GRG, and all we're concerned about is knowing if after the fact, if we can determine whether they did in fact add someone through a written agreement.
well, and it's that determination, it's the clarity of that determination which is desired here. I mean, there's a purpose and a public policy purpose relative to what the requirements are.
What's that public policy?
Clarity, that we don't get into litigation over whether there was a written contract or a written agreement. It's meant to avoid precisely this dispute that we have here.
I guess I would agree completely if there's only a writing by one side and nothing else in writing that evidences that the other side has agreed. But I suppose their strongest argument, or at least one, seems to be that something was sent in writing to KB that confirmed GRG's understanding that there to be a named insured.
And to the extent that you consider that an issue, I think that's an estoppel issue because, again, the lack of consideration that exists. There's not an agreement there. There's not a contract there. It's an estoppel issue. Did you mislead? And that really dovetails into whether there's a duty to speak, so to speak. Is there a duty, an obligation to be clear? Because for purposes of whether there's a written contract or a written agreement that's executed, I mean, the answer is no relative to that. It may be still legally enforceable vis-a-vis estoppel against GRG, but for purposes of my client and for purposes of the requirement, predicate requirement to get a coverage under my client's policy, the answer's no. Well, I see I'm at my 10-minute mark, so if any further questions?
Thank you.
It went too fast.
Thank you, Your Honors.
Good morning. Miles Hassett for Drachman Lead, present in the courtroom, Boyd Drachman. I'm pleased to be here to represent this insurance agency. I do think we have an interesting case, although the Drachman Lead case doesn't have anything to do with the Charter Oak position. The Drachman and American E&S folks are in here only because of the Evanston policy. The Evanston endorsement concerns only language that says per written contract. There's no issue of written agreement, so it's per written contract. Now, the crux of the claim, as counsel stated, against my client and American E&S is whether there was an actionable misrepresentation in anything that they issued to KB, indicating its status as additional insured. The endorsements that were attached to these certificates clearly made that statement that a party would qualify automatically. That's the meaning of this blanket additional insured endorsement, that they would qualify automatically under the policy per written contract. So that meant that the contract between GRG and KB, whatever it is, and whatever it is determined to be, has to include the requirement that KB be added as an additional insured.
In contrast to the old form of endorsement whereby the insurance company would know every additional insured, they don't know this one.
Right, and that's a very good point, Judge Gemmell, because historically, and I think this is raised in the amicus brief of the independent insurance agents, historically, insurance agents were charged to issuing certificates to the world and his brother, if you will, and it became unduly burdensome. As the result, companies developed these blanket additional insured endorsements so that there's one form of endorsement, it can be supplied to the additional insured, and then it's up to them, to the point of another question, isn't it the obligation of KB to check, they get the endorsement, shouldn't they check to see that they qualify? If it says per written contract, shouldn't they do something to understand what their role in the process is if they want to be added as additional insured? I agree. That is their responsibility. Here, the course of this over the 4 years, now to mind the 2 years of the Evanston policy, is that KB makes no objection whatsoever to the certificates or endorsements that are issued by Drachman Lead. Let me address the point made by counsel because it's a little confusing, I think, in the way that it has been presented. Counsel says that Evanston denies Drachman Lead's authority to issue certificates or endorsements, and the endorsement in question for the year 2002 is not in the Evanston file. The whole idea that Drachman lacks authority is really not pertinent to the position under the Evanston policies. It's uncontested that the blanket endorsements were present. And so if KB qualifies automatically, it doesn't matter whether Drachman Lead issued a certificate or endorsement or not. If they qualified, they qualified. So the idea that the authority by Evanston, not a party now to this case, having settled with KB, the idea that some issue of authority raised by Evanston controls the outcome here, that's not correct. The correct idea is, did KB qualify automatically under the Evanston policy as an additional insured? If it did, it did. If it didn't, it didn't. Drachman Lead didn't have a role in making that determination. Drachman Lead didn't write the policy. Drachman Lead conveys information, including to third parties like KB, for the purpose of them understanding what their position is under the policy issued to Drachman Lead's client.
Does Mr. Molinar's argument that Drachman Lead issued an endorsement that they shouldn't have and that they didn't have authority for, does that have any bearing under your analysis?
It really doesn't, because two things. That's the 2002 endorsement. And for one thing, we know that GRG's work, this is uncontested in the record, had finished on the project in 2001. So that's point number one, just as a practical matter. But GRG was doing other work for KB, is the point, but not on this project in 2002 when that certificate was issued. And that...
Would you have been entitled to summary judgment simply on that timing issue?
I think we would have been, but I do,
that wasn't the record that we have.
I think the point I made is in the record and it's in our brief, but I want to address the larger issue because I think we win on the larger issue regardless. The larger issue raised by counsel is that there's a different form of endorsement and it has KB's name on it in 2002. Two things about that. Number one, the endorsement, the operative language in the endorsement is still the same. It still includes the per written contract. It's just that in 2002, KB's name is actually typed on the endorsement. Same difference. If KB qualified automatically, it was entitled to the benefit of that endorsement. The appearance of KB's name on the endorsement didn't confer any additional rights on KB, nor does it claim to have specifically relied on that to that extent. Ordinarily, they said, we got these certificates. We knew better than to rely on certificates. Everybody in the business understands that they are informational only, and provided the form of the endorsement was something that was generally acceptable, KB was fine with that. So what duty then does Drachman owe KB? Does Drachman owe KB a duty to make sure that KB's entire insurance program is proper and operating correctly?
That seems
No.
a little broad.
Yeah, that's a little broad, isn't it? The court rejected that idea in Napier, the Arizona Supreme Court did, and that's still good law. In this case, the only idea that's saleable, for want of a better term, is that Drachman owes a duty not to misrepresent KB's status. And we agree with that. We shouldn't misrepresent their status, but we didn't. We said what they were pursuant to the agreement. Here's the endorsement. It says you are an additional insured per written contract. Could you prove that with Evanston? I don't know. But whether you could or couldn't, Drachman conveyed only truthful information to KB.
Before we lose all of our time here today, I gather that Evanston's settlement does not resolve the claims against Drachman Lee.
Well, it doesn't, although it raises a somewhat curious point, which is when pursuing Evanston, KB vociferously argued that Drachman had authority to issue the certificates and the endorsements, settled, took money from Evanston, and then changed its tune. And I realize that people can take conflicting positions and perhaps positions of convenience. We raise a judicial estoppel argument in our brief, but the point is, I think that the Evanston settlement should not be regarded as something that is necessarily dispositive, but it certainly is interesting that Evanston settled out when confronted with these arguments about whether KB was entitled to additional insured status. And one argument is they've already recovered from the responsible party.
Is there any responsibility on your client's part to, let's say a contract said under no conditions will we cover a general contractor. Is there any responsibility to understand the nature of the contract if you forwarded something saying, your client forwarded something saying, here's an endorsement saying KB is a named insured when the contract specifically said under no circumstances would we cover someone like KB?
Yeah, if you're the client, Judge Kitani, and I'm the insurance agent, I agree with you. I've got a responsibility to look at your circumstance so I can properly guide and advise you on the kind of insurance you need to protect you. But when the insurance concerns a third party, especially a sophisticated third party like KB, no, the insurance agent doesn't owe that duty. I agree that they owe a duty not to misrepresent to KB what the status of the insurance is, but they didn't do that. They offered truthful statements, and we ask that the judgment of the trial court be affirmed for that reason. Thank you.
Thank you.
Okay. I'd like to first address statements from Drachman Lead. First of all, the relevant inquiry in determining whether or not they made a misrepresentation is let's focus on what was requested by KB Home to GRG, which was that KB Home be named an additional insured on that policy and on an endorsement specifically in that policy. GRG forwarded that request to Drachman Lead. Drachman Lead turned around a certificate stating KB Home is an additional insured as per written contract per the attached endorsement. The attached endorsement had KB Home's name on it, which is what KB Home had requested. However, that attached endorsement was not a part of the Evanston policy. That was one of the primary reasons for Evanston's denial to KB Home's claim. In fact, Evanston named Drachman Lead and American E&S as a non-party at fault in this case. Now, if you look at...
Well, really, it's not necessarily then the listing of KB or what they said, but potentially not forwarding the endorsement to Evanston.
Correct. And in fact, Evanston has testified that Drachman Lead was aware and knew and had been cautioned that it was not allowed to issue additional insured endorsements. Now, the issue of written requirement is interesting because if you look at what KB requested, it never said add us as an additional insured per written contract. It said add us as an additional insured. Drockman Lead made that determination. They made the determination that they were going to use a form endorsement that was not part of the Evanston policy that said as per written contract on it, even though Drockman Lead never requested and never received a copy of the KB Home GRG contract. Drockman Lead made that determination to use that endorsement. Drockman Lead sent the certificate saying you're an additional insured per the attached endorsement. Drockman Lead is the one that made this as per written contract issue, but that is not what KB Home requested. Now, moving on quickly to Charter Oak. First of all, Travelers issue, there is sufficient evidence in our brief and on the record that Travelers was a party to the policies. The front page contained Travelers' logo. There's a statement that in return for payment of the premium, Travelers will agree with the named insured to provide insurance afforded by coverage part. Certificates list Travelers' property casualty, and the claim correspondence came from Travelers.
Well, I thought Charter Oak was one of the Travelers' companies.
Charter Oak apparently is one of the one of the Travelers' companies. However, the policies have Travelers' names on it, and so do the certificates. So that will be a question of fact to be determined if we go back down to trial.
Can I ask you a question, please, on going back to these certificates of insurance? And I was able to pull up one of the certificates issued during the Evanston years. I think this is a standard form statement, and this relates somewhat to the disclaimer language that you and I were talking about earlier. But this says, and I'm assuming it's the same for the Charter Oak years, this certificate is issued as a matter of information only and confers no rights upon the certificate holder. And it also says does not amend, extend, or alter the coverage, etc. But the confers no rights upon the certificate holder is of interest to me, because I hear you saying that your written agreement here is paragraphs or section 7 requirements, the insurance requirements sent out every year, coupled with the certificates of insurance. But if the certificate of insurance, according to this, says it confers no rights, then doesn't that run counter to your necessary position here?
Right, and I don't believe that it does, because the certificate was not issued to KB Home in a vacuum. But for GRG's agreement to the insurance requirements and its request to Drockman Lead to add KB Home as additional insured, KB Home would have never received the certificates. And I see that I'm out of time unless the court has any further questions.
Thank you very much.
Thank you.
We appreciate the argument provided here. We will issue our written ruling in due course. We will stand at recess for our next matter. Thank you.